Check, 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 check. Okay. Now we'll be doing commercial law and tax law. Konti lang yung nagawa ko, so pasensya nyo na. But last year, konti lang din yung nagawa ko. Maraming lumabas. So hopefully ngayon maraming lumabas ulit. Okay, wala na uling intro. Let's go. Now, read our disclaimer. Okay, let's start. Problem number 1. In August 1998, Sunoco entered a share swap agreement with Central Flex and Paxu involving 40% transfer of LOL Inc. shares for a 35.5% stake in Sunoco. There was a dispute over the agreement's timing. Central Flex pledged 2 billion Sunoco shares as collateral for Legends loans. In August 2001, Sunoco and Mabel executed an unwinding agreement with Central Flex and Paxu, reversing the 1998 swap agreement. Central Flex and Paxu couldn't return 1.87 billion Sunoco shares, and 2 billion shares remained pledged to the bank. Between 2002 and 2008, Sunoco reduced its authorized capital stock approved by shareholders and regulatory bodies. In July 2008, Chow, formerly Yao, Chow, Central Flex and Paxu filed a petition challenging Sunoco's capital stock amendments. The Securities and Exchange Commission ruled in favor of Sunoco, stating that such reductions are a matter for stockholders and can't be stopped by courts or creditors, and there was no threat to the investing public. Again, the SEC ruled in favor of Sunoco, stating that such reductions are a matter for stockholders and cannot be stopped by courts or creditors, and there was no threat to the investing public. Is the SEC correct? The answer is yes, the SEC is correct. Because the reduction of a corporation's capital stock is a business judgment vested by law to the stockholders and the directors of the corporation. Jurisprudence states that contracts intra vires entered into by the board of directors are binding upon the corporation, and the courts will not interfere unless such contracts are so unconscionable and oppressive as to amount to wanton destruction to the rights of the minority, as when plaintiffs aver that the defendants, members of the board, have concluded a transaction among themselves as will result in serious injury to the plaintiff's stockholders. As such, the Securities and Exchange Commission and the court are barred from intruding into business judgments of corporations when the same are made in good faith. Based on the case of Metroplex versus Sinofil. Second question. SUMA is a corporation organized and existing under Philippine laws. Hans Christian is a corporation organized and existing under the laws of the state of Washington, United States of America. In 1996, SUMA ordered from Hans Christian the form, design, and drawing development for its project on the development of a precast plant and PCTT design. In this connection, SUMA issued a purchase order. The parties also executed an agreement for professional services, which provided that SUMA would compensate Hans Christian for the performance of services described therein. In February 1997, Summa asked Hans Christian to prepare a preliminary design for its Ecocentrum garage project, and pursuant to this, Hans Christian delivered the designs. Summa made partial payments but left an unpaid balance amounting to 60,786 and 59 cents. US dollars pertaining to, first, the precast plant inspection and consultation, second, PCTT form design and plant development design, and Ecocentrum garage preliminary design for bidding. Hans Christian made repeated demands for Summa to pay but to no avail. Hence the filing of the complaint. The contention of Summa was that Hans Christian was doing business in the Philippines but without the necessary license. Hence, it filed a motion to dismiss, alleging that Hans Christian has no legal capacity to sue. Is the contention of Summa correct? Answer: yes, the contention of Summa is correct because Hans Christian, as an unlicensed foreign corporation, has no personality in the Philippines. Under Section 150 of the Revised Corporation Code, a foreign corporation that conducts business in the Philippines must secure a license for it to be allowed to initiate or intervene in any action in court or administrative agency in the Philippines. Since Hans Christian has no personality in the Philippines for being unlicensed, he has no capacity to sue. Based on the case of Magna Ready Mix Concrete Corporation versus Anderson, Bjornstam Kane Jacobs Incorporated. Next case. On December 11, 1991, the court voided Bangko Sentral ng Pilipinas' Monetary Board's order to close Bangko Filipino. Resolution number 427 allowed Bangko Filipino to resume business. In 2002, Bangko Filipino faced financial difficulties and sought BSP's help. During the ongoing negotiations and a proposal for settlement, Bangko Filipino requested 25 million income enhancement loan. BSP in a resolution granted the loan but required Bangko Filipino to withdraw all pending cases against BSP, its officials, and commit not to file similar cases in the future. Bangko Filipino refused these conditions. Bangko Filipino filed a petition for certiorari and mandamus seeking a temporary restraining order and a writ of preliminary injunction alleging BSP's abuse of discretion. Initially granted, the Court of Appeals later reversed the decision. In 2012, the Monetary Board, in a resolution, said that Bangko Filipino was placed under receivership by the PDIC, citing its inability to operate safely for depositors and creditors. Bangko Filipino challenged this via petition of certiorari and mandamus. Petition for certiorari and mandamus. The question is, will the action of Bangko Filipino prosper? The answer is no. The action of Bangko Filipino will not prosper because it has no authority to commence a suit against BSP. Again, no, the action of Bangko Filipino will not prosper because it has no authority to commence a suit against BSP. Under Republic Act 3591 as amended, a bank under receivership loses its authority to the Philippine Deposit Insurance Corporation as the designated receiver charged to administer all the assets and liabilities of the bank, which includes bringing suits in court. All powers of the directors, officers, and stockholders of the bank are deemed suspended upon the takeover of the PDIC, based on the case of Bangko Filipino versus BSP. Next, Ringo purchased a compulsory third-party liability insurance policy from Holdsoft for his 2007 Mitsubishi Adventure, effective from January 16, 2007 to January 16, 2010. He also obtained an excess cover for third-party bodily and death liability from Malayco for the same vehicle, with coverage limits of 100,000 pesos for the CTPL and 100,000 pesos for excess coverage. While the policies were in effect, Ringo, driving the insured vehicle, was involved in an accident with a 6-year-old pedestrian who suffered bodily injuries and required hospital treatment, costing Ringo over 100,000 pesos in medical fees. Ringo filed third-party liability claims with Wholesoft and Malayco. The Insurance Commission ruled in favor of Malayco, ordering Wholesoft to pay Ringo 100,000 pesos and Malayco to pay 318 pesos. Is the ruling of the Insurance Commission correct? Answer: the ruling of the Insurance Commission is correct because the purpose of a compulsory third-party liability is to provide compensation for the death or bodily injury suffered by innocent third parties or passengers as a result of the negligent operation and use of motor vehicles. It cited the case of Western Guaranty Corporation versus Court of Appeals, claiming that the schedule of indemnities in a policy should not limit the amount recoverable as long as the claimed amount does not exceed the insurance coverage and the expenses were for the victim's medical care. From the case of Malayan Insurance versus Stronghold Corporation. Next. On May 29, 2007, KECI registered the Colin trademark for electronic equipment and apparatus under Class 35 without opposition from Taiwan Colin. On August 16, 2007, KECI filed another application for www.colin.ph under Class 35 and Taiwan Colin opposed it. The opposition was based on various grounds, including claims of harm to Taiwan Colin's reputation and business. However, the opposition was dismissed, and this decision was upheld by the IPO Director General and later by the Court of Appeals. They claimed that the registration of www.colin.ph is limited to the services covered by KECI's application, and Taiwan Colin is stopped from challenging KECI's rights associated with the Colin trademark registration. Is the decision correct? Answer: yes, the decision is correct because KECI's rights from its existing trademark registration for Colin do not extend to product and market areas that are the normal potential expansion of its business and goods and services, and those in respect of which the trademark is registered, where such use would result in a likelihood of confusion. Section 147 of the Intellectual Property Code provides that the owner of a registered mark shall have the exclusive right. Again, the owner of the registered mark shall have the exclusive right to prevent all third parties not having the owner's consent from using, in the course of trade, identical or similar signs for goods or services which are identical or similar to those in respect of which the trademark is registered, where such would result in a likelihood of confusion. The court held that the protection afforded to a trademark with regard to goods and services in market areas that are normal potential expansion of the trademark owner's business must not infringe on the rights of another trademark owner with a registered mark in its favor. Based on the case of Colin Electronics versus Taiwan Colin. Next question. Petitioner A and B find themselves facing serious allegations of unfair competition brought against them by respondent Autumnville at the City Prosecutor's Office of Manila. Their charges stem from the alleged willful and unlawful actions of jointly selling, disposing, or facilitating the sale and distribution of facial cream products to the public. What makes this case particularly concerning is that these products were manufactured, labeled, and distributed using tools, implements, and equipment that closely mimic and resemble the Cream Face facial cream products, a brand associated with Autumnville. Such striking similarities in appearance are likely to mislead purchasers, leaving them with the impression that these products originate from Autumnville. Was there unfair competition in this case? Answer: yes, there is unfair competition in this case because all the elements are present. The essential elements of an action for unfair competition are: first, confusing similarity in the general appearance of the goods; second, intent to deceive the public and defraud a competitor. The confusing similarity may or may not result from similarity in the marks, but may result from other external factors in the packaging or representation of the goods. Based on the case of Co. versus Somerville General Merchandising. Okay, I think this is a tax question. Company A faced a series of challenges in its dealings with the Bureau of Internal Revenue. Initially, Company A attempted to cancel its letter of authority, but their request was denied by the BIR. Seeking a solution, they turned to tax amnesty, hoping for some relief. However, the BIR took a different stance and directed Company A to fulfill their ascending tax obligation first. Subsequently, Company A availed of the tax amnesty under RA 9480, and on the same day, Company A filed its tax amnesty payment form and then paid the amnesty tax the following day. A year later, after failing to comply with the collection letter from the BIR, a complaint affidavit was filed against Company A's treasurer, Mautang, and its president, Mapera, for violating the National Internal Revenue Code, Section 255, in their official capacities. In their defense, Mautang and Mapera argued that they were entitled to avail the tax amnesty provisions established by law. Rule on Mautang and Mapera's claim. Answer: the argument of Mautang and Mapera is correct that they are entitled to a claim of tax amnesty. The Supreme Court ruled that tax amnesty refers to the absolute waiver by a sovereign of its right to collect taxes and power to impose penalties on persons or entities guilty of violating a tax law. Tax amnesty aims to grant a general reprieve to tax evaders who wish to come clean by giving them an opportunity to straighten out their records. A tax amnesty, much like a tax exemption, is never favored or presumed in law. The grant of a tax amnesty, like a tax exemption, must be construed strictly against the taxpayer and liberally in favor of the taxing authority. Based on the case of BIR versus Samuel Cagang. Another tax question. Euler Corporation has received a formal letter of demand and a final assessment notice which established its liability for a deficiency in withholding tax on compensation and deficiency expanding withholding tax. However, Euler Corporation asserts that the FAN is rendered null and void due to its issuance beyond the 3-year prescriptive period. Additionally, it contends that it did not receive a preliminary assessment notice prior to the issuance of the FAN, which further compounds the issue at hand. Will the complaint against Euler Corporation prosper? Answer: no, the complaint against Euler Corporation will not prosper because it was denied the right of due process based on the purported failure to receive a preliminary assessment notice. Tax collection must be preceded by a valid assessment to allow the taxpayer to protest the assessment, present their case, and adduce supporting evidence. Without complying with the unequivocal mandate of first informing the taxpayer of the government's claim, there can be no deprivation of property because no effective protest can be made. Based on the case of CIR versus Unioil Corporation. Last question. Red Horse Inc. or Red Horse Incorporated, a domestic producer of fermented liquors, faced a tax dispute related to changes in excise taxes. In 1997, Republic Act 8240 replaced the ad valorem tax system with a specific tax system for products like fermented liquor. This law mandated that the excise tax for fermented liquor should not be lower than the October 1, 1996 rate. In 1999, Revenue Regulation Number 17-99 was issued, implementing a 12% increase in excise tax. Red Horse Incorporated claimed that RR 17-99 did not align with the law's intent and sought a refund for alleged excise taxes paid between 2001 and 2002. The tax dispute revolved around whether Red Horses Inc. Incorporated's claim was barred by prescription rule on the argument of Red Horse Incorporated. Yes, the claim of Red Horse Incorporated is barred by prescription because it was filed beyond the 2-year reglementary period under the law. Under the law, within 2 years from the date of payment of tax, the claimant for tax refund or tax credit must first file an administrative claim with the Commissioner of Internal Revenue before filing its judicial claim with the Court of Law. Both claims must be filed within a 2-year reglementary period. Timeliness of the filing of the claim is mandatory and jurisdictional, and thus the court cannot take cognizance of a judicial claim for refund filed either prematurely or out of time. Based on the case of Commissioner of Internal Revenue versus San Miguel Corporation. Okay, good luck everyone. Kaya yan.